Hello, good people, and welcome back to another contract walkthrough. And thank you for joining me. My name is Raven Willis. I am an attorney located right outside of Fort Worth, Texas. My firm is New Millennia Legal Resources. If you guys have no idea who I am, then I suggest you check out my website, which is www.newmillennialegal.com, and you can join our legal membership site that is just for small businesses just like yours. If you're watching this, chances are you own a small business. And then also we take clients for trademarks and contracts. So every week I decided to go ahead and create these videos where I'm walking through and basically just showing you guys kind of how I think as I review contracts similar to these. Now, these videos are not legal advice. So please do not take what I am saying and then just go run with it. This is just a very broad kind of overview as to kind of what things that kind of trigger my mind and red flags that I see as I'm going through agreements like this. This is not even going to be an extraordinarily thorough review because the videos would end up being 2 hours long and nobody's going to sit through those videos. So this is kind of like top level, but I'm going to walk through it and kind of give you my thoughts about this particular agreement. And then hopefully you'll be able to apply a lot of the information to, you know, your own situation when you're reviewing contracts and things like that. So today we are going to walk through a life coaching agreement that was sent to me. This is not one of my contracts. Let me just say that I do have contract templates for sale on my site, newmillennialegal.com, and it comes inclusive of the membership. This is not one of those templates. I just want to be very clear. Now, this is still, I felt like a really good agreement to walk through because even though, yes, it is a life coaching agreement, and I know everybody watching this probably does not have a life coaching business, but a lot of the things that I'm going to talk about are going to be applicable to a wide variety of contracts for services. So let's get started. Now, this life coaching agreement starts off, you know, the preamble right here that I'm looking at it's very basic. That part of the contract, you know, it's good to put as much information, you know, as you can, but it doesn't have to be super detailed. Right here, this life coaching agreement is entered into as a blank by and between blank client and coach. Okay, so I'm assuming this is going to be an individual. So this is going to be a B2C type of agreement. When you're dealing with business to consumer, it's going to be a little bit different than business to business. Business to business contracts, you're going to have a lot more kind of leeway regarding what's going to go inside of it and, you know, the laws regarding what is and isn't enforceable. When you talk about business to consumer, it's going to be a little bit more strict and you're going to be a little bit more restricted as to, you know, what's going to be enforceable. So anyway, again, just walking through kind of the things that I think of. Now, this beginning part, I feel like, you know, the date is fine. You know, that spot right there for the date is fine. By and between blank the client and coach. What I like to do is I like to make sure that at least there's a little bit more information that's going to be able to identify the client more quickly and more easily. So the way that you do that is you put the client's name, then also you insert some information for their address and, you know, the coaching company right there. That's fine. By signing below, the parties here to agree as follows. You know, normally I like to see kind of right before this section, just something that states really quickly, you know, something about it's assumed or both parties agree that there is a fair exchange, like there is valuable consideration. That's a very specific term of art. I really like to see that word consideration before this section. Yeah. I won't say it's not fatal, but in order for a contract to be enforceable, there has to be consideration. There has to be an exchange. It cannot be just one-sided, you know, one person getting one thing. There has to be that, like I said, an element of fairness. There has to be an exchange of some sort, and the way that the courts describe that is through consideration. So that's why it's very important. Now, it can be inferred through the actual agreement, but again, it's just a lot easier if you just say, yes, both parties agree that there's fair consideration, and then just be done with it. Let's see. By signing below, the parties here to agree as follows. Company offers a program of life coaching services. I'm not going to read this word from word because you guys can read it on my screen. However, I've already kind of read through this and I'm just going to skim through the parts that catch my attention. Client understands that this is not therapy or treatment. That is very, very, very important. I really do like the fact that it says that it is not therapy or treatment because, so let me move my mic closer, make sure you guys can hear me. Because you don't want the person who's undertaking this treatment to think that this is a clinical type of service. You want to stay away from that because that's going to open a whole host of liability issues down the line. So I do like that. Client understands that program will be conducted by coach. Gotcha. Coach name. You know, if you have several people in your company, I don't know if I would put a specific coach name in the agreement because if you change the person who's providing any services, then you're going to have to change the contract. So you want to leave it a little bit more open, I feel. So I personally wouldn't put a specific name in there. I would just keep the company name and then allow you as a service provider to kind of leave that flexible. Client understands that coach is not a licensed professional as it relates to the program and is not a therapist. Psychiatrist, psychologist, dietitian, nutrition, counselor, or doctor. I'm guessing this should be nutritionist, counselor, or doctor. Okay, is not a licensed professional. Okay, I mean, that's fine. I mean, if I was signing on to services, I don't think I'd want to see that. But but if it's the truth, then I'm not going to tell you to take it out. Okay. Client agrees to seek professional, medical, psychiatric, psychological, and or therapeutic help as he or she deems necessary. Okay. Are in no way responsible. Okay, I like that. I like that paragraph. Client understands that the program may cause client to experience extreme emotional states. That's interesting. Again, I mean, definitely don't lie, but I don't know. If I was a client, I don't know if I'd want to see that. It may cause extreme emotional states. I would try to reword that. Client agrees that he or she is fully responsible for managing his or her actions. Okay, I like that. Client acknowledges that he or she is of sound mind and fully capable of understanding the extent and limitations of the program. Will not hold company. So this is like basically an indemnification clause. Okay, I like that. You know what? The one thing that I would like to see in this section right here, so even though it states that, you know, the client's going to be responsible for their own actions and isn't going to hold the company liable, I would still put something in there that is like, okay, even if, you know, notwithstanding what we've said here, but even if by some crazy chance we're going to be held liable for something, the damages are going to be limited to, like, say, however much the client has paid towards these services, like, and you want to limit that, like, say, within the past year or 12 months or whatever, you know. So I think this is good, but again, I would just have another kind of safety net and say, okay, even if we are found liable, then the extent of damages is going to be limited. And then on top of that, you still probably want to limit the types of damages. So like there are direct damages, indirect damages, you know, consequential damages, which is a type of indirect damages. You want to limit it to actual direct damages. So again, terms of art, it's very important. You may not understand what that means, but I promise things like that are very, very important. Results disclaimer. Okay. When addressing nutrition, weight loss, exercise, health, and fitness matters in any of our sessions, calls, videos, newsletters, recordings. Isn't this for life coaching? I don't know. I feel like Exercise, health, and fitness. Okay, so my thoughts about this is that if this is a life coaching agreement, I just feel like why is there a section specifically to nutrition, weight loss, exercise, health, and fitness? I mean, I understand that that's part of life, but at the same time, I just feel like when you say nutrition, that has a very specific like connotation, and if I recall correctly, you have to be a licensed nutritionist. So I feel like I don't feel like that word would be a good idea to use in here, because again, I figured like it's going to trigger a certain set of liability issues. Weight loss, okay. Exercise, okay. Health and fitness, okay. But that just nutrition for me, I don't like that. And then also, I don't know, I feel it's kind of odd that we're calling out nutrition specifically. But, it could be that that's a part of the coaching business. So that's fine if that's the truth. But if you don't have a coaching business that does focus on nutrition, I shouldn't say nutrition, that focuses on healthy eating habits and weight loss, then I definitely would not. Like, I personally, I wouldn't include it in there. This is not a get thin tomorrow magical solution. See, again, I feel like this is focusing a very, like, an unusual amount on the weight loss aspect of it. Seems a little sketchy to me, personally. None of the content in coaching is a promise or guarantee of weight loss. Again, sketchy. We cannot control other factors, including your choices, your hormones, your medical history. Again, I feel like this is a very odd focus on weight loss. Any specific results, health related or otherwise, from any content. Okay. I like that. So it says that basically we're not lawyers, we're not doctors. Okay. And I would even say, just to kind of add strength to that, say it is, client agrees to seek out the help of a professional if legal, medical, financial, advice or information is required. I would strengthen it by adding something like that. Confidentiality, company name will not disclose information the client reveals in connection with the program. Okay, may reveal to legal and law enforcement authorities. That's fine. My only thing about this confidentiality section is, well, not my only thing. I feel like the confidentiality section needs a lot more work. One of the things that comes to mind is that, and I do like the fact that it says that, there is no, doctor-patient relationship, because that's very important, because any and everything you say can be used against you when you disclose it. But here's the thing. If you ever have to report the client for like non-payment, for instance, if they have a past due balance and you want to submit it to a credit reporting agency or you want to submit it to a debt collector, then you're not going to be able to do that with the way that this confidentiality section is written. So if you haven't, I can't remember what the payment section says, but if you have not received your payment in full, then I would just still make some, if you haven't received your payment in full upfront, then I would still make maybe just a little bit more wiggle room just to allow for third parties to collect on a debt. Appointment scheduling and payment fees. You agree to pay per package for the program. Gotcha. Paid up front. Okay. So it may not be an issue, but still, you never know. Under certain circumstances. Okay. Client may qualify for a payment schedule. So yeah, because of that, I definitely would go back and include some provisions for debt collection and maybe even include in this agreement, maybe what you do with their information, like how you store it. Like if you store it in the cloud, or something, I would say something like that in here as well too, in the confidentiality section, or maybe in another section. It doesn't have to go in the confidentiality section. Let's see. So this is all payment. I don't see where it says what types of payments are accepted. So can they pay by check, Cash App? Not that I recommend Cash App. PayPal, credit card. It does say I agree to have my credit card debited, but it doesn't specifically exclude the other methods of payment. So I think definitely that should go in there. And then also, it doesn't say anything about timeliness, and that's a big thing. So what if the client is late and they don't show up? What if a client is late, say by 30 minutes? Is there a certain time that you wait until the client is marked as having forfeited the session? I don't see that in there. 24 hours notice prior to canceling. Okay, that's good. And so this fee, is it going to be charged to them separately, or is it going to be deducted from the amounts that they paid? I would want to know that. It says if you've paid for sessions, okay. In certain unusual situations, you may need to cancel future sessions. If that need arises, we require a 14-day advance notice. If you have remaining sessions that you have paid for and did not use, you are entitled to a refund of those sessions. So what if, you said that you need a 14-day notice, but what if they cancel and say they have a session or 2 sessions in that 14-day notice? Are they going to be refunded those sessions, or are they forfeiting those sessions if they fall within that, if they fall inside of that 14-day buffer, or what? I'd want to know that. And if you do refund the money, do you have any types of administrative costs that you're going to have to, hold back? It doesn't sound like it, but if that's the case, because I know a lot of us service providers, it takes time and effort to be able to set up a client, onboard them. So if they cancel, you never know. Are you going to, you may want to try to recoup some of that loss by just, by not refunding the entire amount, but that needs to be clear here. Okay, so that's the end of the contract. Oh, here's the thing. And this contract is like the other contract that I reviewed last week. This is a pretty good statement of work, but it does not have all of the legal jargon that I really, really, really like to see in contracts. Actually, there's one more thing. So by company name, sole member, I feel like that's just kind of strange. I personally wouldn't put how many members your LLC has. I don't think that's relevant, but so I feel like this is missing a lot of information, actually. There's no terms regarding severability. There's no terms regarding, assignments, notices. What's the official email address? What's the official phone number that you should use or that they should use and to notify you of an emergency? There's none of that in here. And then also, I feel like with these types of agreements, there still should also be something in there like, okay, here are what our sessions are going to look like. Don't be so specific where it doesn't give you room to work with. But at the same time, I think it would be a good idea to give the client an idea of what's going to happen. And then also include some information of what's going to be expected of the client. Like, for instance, I expect you to, be here on time. I expect you to, try to have an open mind, or, you don't want to put too much on there. But still, you want to make sure that the expectations of both parties are going to be, clearly stated in this agreement. And it doesn't quite do that. So even then, because of that, I don't know if I'd even say that this is a good statement of work now that I think about it, because it's really not even describing what's going to be done. I feel like it still should explain, okay, what is life coaching? What is this? And it doesn't even do that for me. Let's see. I have my checklist here. So if you guys are still watching, you'll see that I'm using my checklist. So this right here is absolutely key. I created this checklist that has 70 points in it for things that I look for in all of my contracts when I review them. This is for sale. Well, it's not for sale separately, but it's on my membership site. And if you are a member, then you can log in and just do a search for checklist. I think it should be one of the first documents that's listed on the members dashboard. But this checklist right here helps me. Again, it's got 70 points and it keeps a lot of things from slipping through. So I'm not going to go through the entire thing because again, that would make the video too long. But there are some things again that are missing that I would like to see. Like for instance, changes. How soon does the person have to? Well, I guess it does say you have to give a changing or canceling appointment within 24 hours notice. Yeah, okay, I get that. Yeah. But then also maybe the service provider, the life coach wants to leave some wiggle room, like things that can be changed unilaterally, because right now you can't change anything unilaterally. So maybe reserve some things for you to be able to change by yourself, like say if you post it on your website or things like that. That's something to take into consideration. So the way that you do that is you just write some verbiage in the contract that says, for X number, X items, we will retain the right to change unilaterally, provided that we give you notice. So that's how you do that. Let's see. It doesn't say when the contract will end, but I feel like because it's kind of, it's in packages, I feel like that may not be absolutely necessary. But, one thing that I did notice, it doesn't talk about under what conditions you will be able to terminate the services that you provide. Because, say if the client becomes onery, say if they're not working towards whatever, then you reserve the right to terminate. I know it does say, you can do it kind of at your own discretion, but I still feel like it's a good idea to outline these types of things in the contract for the client. So let's see, what else? If you are going to have other coaches to possibly provide services for this, you still also might want to put in maybe well, I was going to say like a non-solicitation, but I don't know if that would be necessary. That might be something that you'd have to include in the agreement with the coach itself. So we'll just scratch that. Let's see. So I did talk about the notices. There's nothing in there for notices, severability. There's nothing that talks about the governing law. There's nothing that talks about jurisdiction, venue, where cases, not cases, where suits should be brought. I personally am a huge fan of arbitration when appropriate, not in every single instance, but in a lot of instances. There's nothing in there that talks about, dispute resolution. So the bad thing about not including verbiage in there for that is that normally if somebody has an issue, the only recourse they have is to take you to court. And there's no in between. So things can get really bad really quickly. So I like to include some provisions in there to try to help the parties resolve a dispute as quickly and as amicably and as cheaply as possible. So for me, arbitration does do that if it's written in the right way. And severability, I already talked about that. Assignments, you want to still include something in here that talks about, this is between you and me. You do not have the right to assign the benefits of this contract to anyone else without my approval. You don't want somebody saying, I can't use up the rest of my sessions, so I'm going to give them to my brother. And there's not anything like that. It's probably not going to happen, but you never know. I've seen some pretty crazy situations. People try a lot of different things. So I hope this helps. Again, I have like literally 30 more things to go through, but I won't go through it. It's a lot of nitpicky detail. If you guys think that this was helpful, then let me know in the comments below. But then also, if you need help with your contract and you need a review, then definitely hit me up. Send me an email at raven.willis@newmillennialegal.com, and I will definitely help you out with that if I'm able. So, alrighty guys, let me know what you think. Hopefully this was helpful. Ask me questions if you have questions below. I would be thrilled to answer them for you. Alrighty, we'll see you next time. Bye.